The question becomes, well, what if you don't take the person into custody? What happens if the person goes and an hour later goes and kills someone? Are you on the hook? Are you civilly liable? Are you responsible? Or are you going to be SOC'd under department policy? And the answer to this question is no. If the person is not committing a crime, you have decided to clear the call, you are not responsible. So let's talk about a couple of issues. First, let's talk about the Legal 2000 statute and department policy. NRS 433A.160 is the Legal 2000 statute, and that statute says that an officer who has probable cause to believe that the person is a threat to himself or others may detain the person and petition for an involuntary commitment. The key word is may. It's not mandatory. You're never required to do a Legal 2000 under Nevada law. And in fact, LVMPD policy 3.400.6, which talks about a Legal 2000, does not require you to do a Legal 2000. But it does caution that if you decide to do so, you have to follow certain steps with respect to contacting a supervisor, a CIT officer, and you have to de-escalate the situation. And so neither Nevada law nor department policy mandates that you take a person into custody for Legal 2000. And some people ask, well, what about neglect of duty? Well, LVMPD policy 8.147 is the neglect of duty policy. And key to that policy is that before you can be neglectful, there has to be an obligation on the officer's part to do something. There has to be a law that mandates that you enforce it, or a policy or a regulation. And none of that exists. And so if you decide not to do a Legal 2000 when the person is not a threat to others and has not committed any crimes, you can't be SOC'd for neglect of duty. So that is the Nevada statute and Metro policy. Now let's look at the U.S. Constitution. And the U.S. Supreme Court has been very clear that the Due Process Clause and other constitutional rights are intended to be limitations on the government's power to intrude upon your lives. It is not a mandate that government do certain things. And so I want to read you a quote from this U.S. Supreme Court decision, and it's the Cheney versus Winnebago County Department of Social Services. And Justice Rehnquist, one of our great conservative justices, wrote, "Nothing in the language of the Due Process Clause itself requires a state to protect the life, liberty, and property of its citizens against invasion by private actors. The clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimal levels of safety and security. It forbids the state itself to deprive individuals of life, liberty, or property without due process of law, but its language cannot fairly be extended to impose an affirmative obligation on the state to ensure that those interests do not come to harm through other means." And so there is no constitutional right to police protection. There is no constitutional right to have an officer do a Legal 2000. And so set that aside. There are two exceptions that the Ninth Circuit and I believe other circuits have carved out. And one is the state-created danger exception. And so when you as a police officer create a situation where a person can be hurt, you have to take reasonable steps to make sure that they're not hurt. Otherwise, you could be sued. And so one of the cases that came out of Montana, a guy was drunk in a bar. The bartender had enough, called the police. The police showed up. The guy was outside. He had a t-shirt on and a pair of jeans, did not have a jacket. It was freezing cold in the middle of the night in Montana during the winter. The guy walks back into the bar. The officers walk him back out and tell him, go home and sleep off the drunk. The next day, the drunk is found literally frozen to death. He died of hypothermia, and the guy's family sued the Montana Police Department, and the Ninth Circuit said, you created this danger, and because you created the danger by kicking him out and not making sure that he had a way home, you are on the hook for not being negligence. That kind of makes sense. And so, you know, if you pull over a female over on the side of the road and you tell her, we're going to tow your car, and you don't provide transportation for her or he, and that person is raped in the middle of the night, you could be on the hook. And the second exception is the special relationship section, and that merely means that when you take someone into custody, you have to take reasonable precautions to make sure that they are safe. And so if they're having medical issues, obviously call medical. You know, if someone is going to attack them, you have to take steps to make sure that the person who is in your custody is not hurt. And so that's the constitutional issues. Nobody has a constitutional right to police intervention in a situation where the guy is at home or the gal is at home threatening to commit suicide. They're not a threat to others. They haven't committed any crimes. There's no constitutional obligation for you to do a legal 2000. And then finally, Nevada law, and this is NRS 41.0336, the public duty doctrine. And generally that says that police officers have a duty to the public or their department, but not to individuals. And so let me read this statute to you. It says, a law enforcement agency is not liable for the negligent acts or omissions of its officers unless, so that's the general rule, you don't owe an obligation to provide police services to any one individual. And that's the same thing for firefighters, by the way, with two exceptions. One is if you promise the individual police action, you promise to protect them, and you don't, and the person relies on your promise, you could be held liable. So, for example, you're a narcotics detective and you're dealing with an informant, and the informant gives you information, and the informant says, you got to promise me that you're going to protect me and I'm not going to be killed for snitching. You don't make that promise, A, because you can't keep that promise. You can't be with the person every minute of every day. And then secondly, you don't want to be on the hook in case the gangbanger goes out and is killed by another gang or whatever the situation may be. And the other exception is if you affirmatively harm someone. And that makes sense, right? I mean, if you use excessive force or you do something to hurt someone, or you're involved in an automobile accident and you hurt someone, obviously you're going to be responsible. So that is the totality of law. I've talked to you about the Legal 2000 statute, Metro policy. Neither one requires you to do a Legal 2000. The U.S. Constitution, the U.S. Supreme Court has said that people aren't guaranteed, constitutionally guaranteed police action. So the person who is threatening to commit suicide isn't guaranteed that you are going to step in and save them from themselves. And then, of course, the Nevada statute, the public duty doctrine, which says the very same thing. You're not responsible for taking police action, but if you promise someone something, you have to fulfill your promise, or if you affirmatively hurt someone, then you're on the hook as well. I understand that all of this sounds cold, but the bottom line is I am your lawyer. I'm here to protect your legal interest. And so what I'm telling you is that if you go to a 405Z call, the person is not a threat to others, you can clear the call, and you're not going to be responsible either by department policy or any particular laws. Thank you very much for listening to these videos. Please contact me if you have any questions. I'm going to provide a memo with all of this as well, so if you want to take a deeper dive, feel free to do so. And as always, please stay safe.
111, 110.